Okay. Uh, it's kind of interesting to think about the way in which research on human subjects, kind of came into being, uh, because it was an awfully long time before that happened. Most of the research on human subjects, or the research done on humans prior to, say, World War II, was done with very little legal oversight. Most of the research was done within particular codes that different, professional organizations might have had. Like the AMA had one code for medical research. The AERA had another code for research in human subjects that was educationally related. NIH had another code for research that was more, social services related. So there were a lot of different ways in which codes were dealt with, and in which human subject research was dealt with, and how it was limited and how it was controlled. But that kind of ended after World War II, and we'll kind of look at kind of that chronology here in just a second. But the main thing that happened over the years is that as the research became more complex, the potential for human subject abuse became more apparent or more relevant. And you can think about some of the research that was done on, for example, the Krathwohl's research on, Kohlberg's research on moral development. That was research that couldn't be done today because it involved, creating mental stress and discomfort to subjects, and with the idea that mental stress and discomfort would be somehow allow them to tap into some sort of stages of moral development. And although that's a fairly important piece of research and a fairly important theory in terms of decision making and the different things that we might look at today, it was done in a manner that had very little concern about any damage that it might do to people. And at the extreme end of the scale, you think about what happened at Tuskegee, where they literally infected African American soldiers with syphilis just to see how the disease would progress, and look at the different stages of disease. And these things occurred, and when we put mental patients in mental institutions, we regularly did research on them. And in fact, one of the pieces of research that we did came out of the whole eugenics movement in the early 20th century, was if a young female of childbearing age was committed to a mental institution, she was sterilized automatically. And that happened not just in a state or two, it happened across the country. And that was occurring up until the 70s and early 80s. It was only, kind of after that we had laws that kind of outlawed that. And so a lot of these abuses were occurring in human subject research, but we were not too awfully worried about it or too awful bothered by it until after World War II. And so what happened in World War II? What happened in World War II was that the Nazis, the Germany, took the whole eugenics notion to an entirely different level. And they started doing, medical research and fairly cruel research on captures. And so they had, in some of the concentration camps, they were, separating twins and doing things to one twin and then, seeing if that twin changed as opposed to the other twin, or they were basically, removing organs or things like that just to see what impact it had, and using different sorts of chemicals and different types of substances on individuals just to see what impact it would have. And so there was a lot of really almost to the point of extreme torture things that were going on during World War II, primarily propagated by the Nazis in Germany. And so after World War II, there were the Nuremberg trials, but also the Nuremberg sort of international conventions. And part of that process was trying to figure out, okay, what these people did, what they did to these people was, inhumane and certainly atrocious. But the argument they made, which wasn't a very strong argument, and they all ended up, primarily being executed. But the argument they made was that, there was nothing in law or science that prevented them from doing it. And so out of Nuremberg came the Nuremberg Conventions, and let me pop that up. Let's see, it's over here. Lost it. Let me go back over there. Are essentially the Nuremberg Code, and this came out in 1949. The Nuremberg Code talked about, how do we go about protecting people engaged that are subjects in human subject research or human research. And so they came up with 10 guiding principles out of the Nuremberg conventions, the Nuremberg trials. And so this was the Nuremberg Code. And it had certain elements to it that kind of carry through into everything that we now have as a part of the legal environment of research. The most important of which is the voluntary consent of human subjects is absolutely essential. And so people have to be able to consent, and not only consent, but with informed consent. They have to know what the risks are, they have to know what the advantages are, they have to know all those things, and have to voluntarily consent to be a subject of research. And you can read on down, and the experiment must yield fruitful results for the good of society and humanity, and the methodology needs to be one that doesn't endanger people. The reasons for doing a study need to be expressly laid out. The potential damages, the trade-offs need to be expressly laid out. So this was essentially what's called the Nuremberg Code, and it came out in 1949. And was supposed to provide some guidance for how we do human subject research. And it did to an extent, but once again, it was still up to the individual entities, the individual professional bodies and legal bodies to determine how they were going to implement these notions from the Nuremberg Code. So there were still a lot of things that we didn't, there was not a lot of consistency with. And so from the Nuremberg Code, by the early 60s, let me mess with this thing here just a little bit. Okay. By the early 60s, the U.S. government, as a result of the what happened with Sputnik and the kind of the push to build a better educational system and a better system to kind of support science and math and all those things, we pumped an enormous amount of money into the system to fund educational experimentation within the schools to improve schools. And it was called I think it was 1964, 65, it was called the National Defense Education Act. And that National Defense Education Act has been renewed every, so often, 5-6 years since the early 1960s, since 64, 65. And we just call it the Education Act now. And so ESSA is the latest version of the Act. The No Child Left Behind was the previous version of the Act. So it's, it's been continued over the years. But what it did, it put enormous amount of federal funds, enormous compared to the previous funding, enormous amount of federal funds into research and education. Now, a lot of good things came out of that. Special ed came out of that. Bilingual ed came out of that. Early sort of versions of STEM came out of that. A lot of things came out of that National Defense Education Act. But what we also figured out is that there was not a lot of accountability in terms of how the research was done. And so a whole field of what's called evaluation research developed. But even that was not enough to really provide, kind of strict accountability of these research efforts based on this federal dollar to be consistent with the Nuremberg Code. And so the sense was that we needed a law, we needed a federal law which would supersede any and all state laws and any and all professional codes that would drive what we had to do and how we had to deal with human subject research. And so in the early 70s, actually one of the last things that Nixon signed off on, but in the early 70s, a commission was brought together of leading educators, leading medical folks, legal scholars, called the Belmont Commission. And in 1979, they generated what's called the Belmont Report. And the Belmont Report was specifically speaking to the Departments of Health, Education, and Welfare, but it also had representation from the Department, what would eventually become a Department of Education, and what would be the Department of Labor and other funding agencies. And it was a statement of the ethical principles and guidelines for the protection of human subjects in research. And it was the study was commissioned, or the commission was charged in 1974, and it took them 5 years to generate a report, because there was a lot of contention, a lot of things going on, in terms of how would it limit medical research, how would it limit other kinds of research, and so there was a lot of debate, a lot of back and forth. But by 1979, they had produced a report. And the report had some fairly, high-powered folks on it. You had lots of medical folks, lots of legal folks. And it was basically built around, what would be good for medical research would be good for all types of human subject research. And they came out with 3 important what they called ethical principles. And let me see if I can. Their basic ethical principles were respect for persons. In other words, once again, the idea that people had to have control of their own bodies or their own, minds and things like that. And so there had to be respect for persons, which led to notions of voluntary consent. Research had to have some benefits. In other words, it had to have some potential benefits, and the benefits had to outweigh the risk and the harm. And there had to be justice involved. It had to be research that was not, targeted toward one group of people or one race or one gender or anything like that. That had to be, some justice involved in how the research was done. And it went on to, talk about, how these things would be applied. And the most important one of those applications was through this concept of what's called informed consent. That people had to be able to give consent to research they might be involved in. Well, after the Belmont Report, there was a push to write a federal law and get the federal law into code. That took a few years because once again there was a lot of debate, there was a lot of back and forth, a lot of committee work, a lot of writing of guidelines, things like that. But by the late 70s into the early 80s, Congress passed a law and a series of additions to the law that was called Protection of Human Subjects, and it's a part of the Federal Code, Title 34, Part 97. And so it's a federal law. And it was designed to supersede any and all state laws and supersede any and all professional codes. And so if you wanted to get federal dollars or dollars that were pass-through dollars from federal foundations, like NSF or NIH or any of the quasi-federal foundation agencies, then you had to meet the requirements of Title 34, Part 97, Protection of Human Subjects. And so it was, and it had some additional components to it that we won't really get into, but we'll just talk about the basic idea here. The idea is that it very succinctly defined human subject research, a systematic investigation including research, development, testing, evaluation designed to develop or contribute to generalizable knowledge. And it's very simple, very straightforward sort of definition. And they realized early on in writing this that there were things that happened as a normal course of events in medicine and education that were could be classified as research that were really just normal things that happened. For example, a doctor might prescribe something that's a pill or a drug for something that it's not been approved to treat off books or off whatever they call it. There's a term they call it. And that's entirely legitimate because the doctor in their sort of wisdom and experience may have discovered that this particular substance works really well for something that it wasn't approved for. And, I'm particularly familiar with that because there are a lot of, people like me that have some back issues and things like that. We have, I have a lot of nerve pain in a leg and in part of my back. And there's not really much you can do about it. I mean, you could go in and rebuild my whole back and stuff like that, but that's a little extreme. And so the trick is to control the nerve pain. Well, a lot of the early antidepressants at a lower dose they discovered were really good for nerve pain, even though they weren't approved for that. And so that's kind of the off-book use that doctors might do. Well, that's not really research, but it's they're experimenting a little bit to see if it works with you, but it's not really research. Or in education, if we're trying some new curriculum method or some new instructional method, and we're trying it out, that's not really research. That's just improving instruction or improving curriculum. And so they had to figure out, what were these things that could be construed as research that weren't really research, and what could we exempt from following the code. And so they came up with 6 categories of research exemptions, one of which is things that are done as a normal course of practice in an educational institution. Anything that's research involving the use of cognitive tests, survey procedures, interview procedures, or observation of human behavior. I mean, if a person fills out the survey, that's informed consent. If they don't, it's not. Research using educational tests, I just mentioned that one. Research involving the collection or study of existing data. And so if you have data that was collected for some purpose and you access that data, the existing data for another research purpose, that really doesn't require informed consent. It would be logistically impossible anyhow. Research that's done as a result of something that a federal agency or state agency requires to happen, like accreditation, or every year the Department of Education collects the a study or a survey that they do around the country, and they'll just go into the school and say, we need 50 random subjects to take this test. And it's the, national, what's it called, NSEA, and yeah. But it's a federal test, and so schools have to do it, and that doesn't require informed consent. And anything that's related to food or public health doesn't require informed consent. And so all these exemptions are possible, but how do you know if you get an exemption? Well, institutions that do research have to create what are called institutional review boards. App State has one. Most school divisions have one, large school divisions, some of the small ones don't. All community colleges should have one. All private schools should have one. And there's a whole series of requirements for institutional review boards, how they have to be composed, who has to be on them, all those sorts of things. And they're the ones that can determine whether you're an exempt category or not. Now, they cannot be overruled administratively. So, for example, if the Institutional Review Board at App State says, this particular piece of research can't be done because it doesn't meet, the standard, then it's not like a dean or a provost or anybody can overrule that. The researcher just has to change the research to meet the guidelines. And so the Institutional Review Board has a great deal of power over research, but at the same time, they typically don't try to get in the way. They just want to make sure that you're following the law, that you're doing what needs to happen. And then there's a whole, process in the code for how institutional research needs to happen, or our institutional review boards need to run. And so the federal code, Title 34, Part 97, was the initial code for human subject research that put it into law. Well, what were the sanctions? Since most entities that were subject to this would be receiving federal funds in some way, it would be the loss of federal funds or the suspension of federal funds. It also would create perhaps a civil liability. That if you violated one of the part of the code and something happened, you could be, civilly sued. And so there is the sanctions are not criminal, they're not felonies, but they are civil, and it can be the loss of money for an institution. And some research-based institutions get hundreds of millions of dollars a year, if not billions, from federal research grants or foundation research grants. And so it's almost a death sentence for institutions to violate the federal codes. That went into effect, and by and large, it worked pretty well up until somewhere in the early 90s. And then there was a concern about who owned student records in education. Who owns the records? Who owns the files? And so the federal amendment, or a federal subpart to Title 34, called Part 99, is called FERPA. And you may be somewhat familiar with FERPA. You may have run into it. It's the Family Educational Rights and Privacy Act. And what FERPA does is it establishes ownership of students' records. And students' records are owned by the students if they're over the age of 18, or the students' parents or guardians if they're 18 or under the age of 18. And so the records are actually owned by the student or their parent or guardian if they're under 18. Now, it gives students and their parents certain rights to the records. Parents and students have to be given the right or the access to inspect student records. Schools don't have to provide copies, free, for free, but they may charge a reasonable printing fee, a copying fee, if they provide a copy. Parents and students can place what are called rejoinders into student records. If they see something in the record that they don't think to be true, they can put a rejoinder in and offer their side of it and why they think it's not true. And in general, schools must have written permission from parents of students under 18 or students if they're 18 or older in order to release any information from that record except for the following exceptions: school officials, other schools to which students transferring, officials for audit or evaluation purposes, financial aid in connection with financial aid applications, organizations conducting studies on behalf of the schools, accrediting agencies, judicial orders, and appropriate officials in the case of health and safety emergencies. Now, a couple of things here. One, students do not have to provide their parents with permission to view their records when they turn 18. And, with my two sons, we kind of came to an arrangement. If you want me to write the tuition check, I want to see your grades. And I want to see your schedules. Now, by legal law, by right, you don't have to allow me to do that. But also by right, I don't have to write those checks. And so we worked on a nice transition for that. When I was the director of institutional research, or director of institutional effectiveness at the community college I was at for a while, basically I was the owner of all college data and college records. And everything had to go through me. All clearances had to go through me. All requests had to go through me. And so occasionally, probably several times a semester, I'd get a call from a parent or a guardian and wanting to know what were John's grades. John hadn't shared those with them. Well, I said I would have to tell them, well, if John's 18, he doesn't have to share those with them. By right, he can control those records. And so, there were occasions when that occurred. The other occasion was this can comply with a judicial order or lawfully issued subpoena. Now, what schools can keep, unless students or parents opt out, this is an opt-out, not an opt-in, unless they opt out, what schools may keep and may disclose is what's called directory information. That's like students' names, periods of attendance, degrees, things like that, addresses, phone numbers. And so, they can create a directory. But if a parent or a student says, I don't want you to do that, they have to sign a form that opts them out of that, then they're not in that directory. Now, if a law enforcement official comes in and says, I want to see all the information you got on so-and-so. And this happened to me a couple of times, and I even got threatened to be, well, I'm going to charge you with this, that, and the other a couple of times. If they don't have a court order or a subpoena, the only thing I could share with them was the directory information, and I could only share that if the student or parent hadn't opted out. And that created a little, contention every now and then. But it was, part of the federal code. There was nothing I could do about that. Now, if there is a search warrant or a subpoena, it has to be very specific about what they need to see. And it can't be a blanket thing. Now, the only exception to all of this stuff in FERPA are military recruiters. They can ask for anything they want to know. And as a, educational institution, I had to provide it. So if they wanted a list of all students that were in good standing, that had 2 math classes and passed them with a B or better, and had 2 science classes that they passed with a B or better, I had to generate that list, provide it to them, and I had 72 hours to do it. And so it was, the big, compliance thing here is with military recruiters. Otherwise, access to students' information is controlled by FERPA, and it's part of federal code. Well, there were a sense among some that FERPA didn't go far enough, that it could have gone further. And so in the mid-90s, late 90s, they passed Part 98, or amended Part 98, to include what's called Protection of Pupil Rights Amendment, PPRA. And what it did was there was thoughts that some of the surveys that were being done, some of the stuff that was being collected in schools might still be, collecting too sensitive information and information that was violating privacy. And so the PPRA said that there were 2 ways, had 2 major components. And the first is that anything that a school is going to use, whether it's textbook, curriculum, survey they're going to give out, whatever, has to be available for parents to view and inspect and offer comments about. And most schools have processes by which, when they're doing textbooks or new curriculum or whatever, there is a period of time which parents are able to come in and review those things. The second element of that was that you had to secure active written parental permission before students under the age of 18 could answer questions or could provide information around certain categories of information. And those categories were political affiliations, mental and psychological problems potentially embarrassing to the student or his or her family, sexual behavior and attitudes, illegal, antisocial, self-incriminating, and demeaning behavior, critical appraisals of other individuals with whom respondents have close family relationships. Now, this one has an interesting outcome, unintended effect. If a student comes to school and has potential signs of abuse, you can ask the student what's wrong. You can refer them to the school health official, school nurse, or you can refer them to guidance and counseling. You can refer them to administrative folk, but you cannot ask them who did this. That's off limits. Now, if when you say, is there something wrong? What's wrong? And they say, well, my father beat me or my mother beat me. Okay. You can't go any further, but you can refer them directly to law enforcement or social services. But as a school personnel, not a counselor, not a nurse, you cannot ask them about that. Now, but by code, you have to pass them off to someone else. You can't ignore it. You still have to notify someone. There also, you can't ask questions about legally recognized privilege, such as those with lawyers, physicians, and ministers, or you can't ask them questions about income or other socioeconomic data. And all these things are off limits for educational personnel without active, signed, formal consent from the parents. So since FERPA was opt-out, Protection of Pupil Rights Amendment is opt-in. They have to say it's okay to ask those things before you can ask them. Now, as a school personnel person, someone that's been in schools and somebody who's worked with schools, I know there's a way around some of this. If you have questions you want to ask about sort of health-related issues or things like that, you can attempt to solicit, the help of the health department, because the health department or a medical professional can ask any of these things. But there has to be a legitimate reason to bring them into play. But as a school personnel, without active parental permission, you can't ask any of these areas. You can't get into it. Even the income stuff, for school lunch programs or financial aid, that has to be secured. That's secure information. It has to be under lock and key. There has to be a data keeper assigned, and there's all kinds of guidelines in terms of any information about students, particularly under the age of 18's income level or socioeconomic level. Now, the good news is, with the exception of PPRA, you can't get past that. But with the exception of that, most of the things that you do in normal educational practice are probably exempt from Title 34. But it's always better to ask first. So ask the administration, ask whoever is, sponsoring something, to ask those questions about, okay, can we do this? Is this within the bounds of the Federal Code on Human Subject Research? Because that way you kind of leave the decision to someone else and the liability to someone else too at that time. Okay. Any thoughts or comments about the legal environment stuff? Have any of you any of you encountered FERPA or any of those elements that you have to deal with? Yeah, I mean, Kelsey, I know you have, because you're dealing with clients in privileged settings, and so you have to make sure that you're within the bounds of what you're allowed to do. And so there's always, when I was fiddling around with counseling much earlier in my career, there were always guidelines as to what you could ask and what types of procedures you could use and what types of processes. When you're in school settings, there's always limits as to, if you think about library media settings, what people check out. That's a privileged sort of thing. And you can use in an aggregate form circulation records, but you can't in a independent, a identifiable form, individual circulation records, because that would be a violation of privacy. And so you always have to be aware of what it is that you can do, what it is you can't do. And but generally, if you're doing stuff within the normal course of events in a professional setting, and if you ever have a doubt, you ask your immediate supervisor or someone that's kind of handling those things. Most schools have somebody that's supposed to answer those questions. Most of the time, it goes through guidance, and I know it's kind of hard to see the guidance person sometimes. But if you have a school psychiatrist or school psychologist, they can always answer those questions because they deal with it pretty much all the time. What can be asked and what can't be asked, and what can be said and what can't be said. So there is there are limits to what you can do. You just need to be aware that those things exist. All right, and I'm reading the email here, or the posting of Kelsey. Yeah, exactly. You're talking about, things like taking pictures or, you can, uh, for example, when you're observing behavior, you can't observe behavior in an identifiable form. But if you record the behavior, you can't share that information, that recording, unless you have identified the folks in it that are identifiable. You can see their face, you can see whatever, and gotten their permission to do it. And so it becomes, you have to kind of weigh out, what's the advantage of collecting certain types of information versus the disadvantage of what permissions you have to get to be able to do that. And so there's always, those sorts of things that you have to be aware of. And there is a FERPA list. Every institution will have a FERPA list. It'll have a list of those individuals that have opted out. And so they don't show up in directories. They don't necessarily show up in, it's always been interesting to me that they don't want to show up in a directory, but they sure want to show up in the yearbook. I mean, that's kind of, one of those deals. But, you just have to be aware of it. It's just something that you can get tripped up on. And as I said, the sanctions are more institutional sanctions and or potential civil liability. But not necessarily, there's not necessarily, unless it's a licensure thing or something like that, there's not really a kind of a legal sanction to most of it. But it's still not something that you want to do. Can be big trouble. Okay. Any other questions or thoughts about the legal environment stuff? Now, we didn't even mention ethical. We just mentioned legal. And one of the things that sometimes have to deal with is things that may be legal may have issues being ethical. I'll give you the quick example is we know absolutely nothing about Head Start programs. I mean, in solid research, we know nothing about how effective Head Start programs could be. Now, our preschool programs can be, because you can't do a randomized experimental study on Head Start or early preschool programs, not because it would not be legal to do, but because in most instances it would be unethical to do. Because if a program has the potential to help students, how can you, in a random draw, identify which students you're going to help and which students you're going to not help? And the answer is you can't. And so the reason we don't know much about preschool handicap or preschool, early preschool programs or Head Start programs is we just can't do the research on it. Not because it would be illegal to do, but because it probably would be difficult to clear sort of ethical hurdles to be able to do it. And so there are, things we can do that, are entirely legal, but they may not be ethical. And so there's always the ethical question to ask over and above the legal question to ask. And sometimes that's a struggle. Sometimes it's something you don't want to do. We had give an example, when at my previous institution where I was at for 30 years, for about 12 or 15 of those, I sat on the institutional review board. And I kept getting re-elected to it. I think it was because nobody else wanted to do it, but it was because I understood the law pretty well. And we got a request from a researcher at another institution that wanted to survey students at our institution and use an instrument that they were developing to try to identify potential eating disorders among college-age females. And they were wanting to do a study across several institutions. And we fit sort of a category of institution, a comprehensive institution that they wanted to look at. And they wanted to come in and identify, you know, a random sample of a couple hundred incoming or upcoming sophomore female students and offer them to take this instrument that identified potential early signs of eating disorders. And as an institution, we had to look at the ethical issue there. And the ethical issue was, we asked the question, what happens to the information that you diagnose as a result of these instruments? And their response was, well, we would share the results with the students. If we identify students that we think, you know, are potentially at risk, we'll share that information with the students and encourage them to go seek help and counseling with the health center and the counseling center. Well, as an institution, normally these IRB things involve one or two people reading a request and deciding whether it's exempt or not, or whether it can be done or not. This one ended up being a full hearing among the full institutional review board. At that time at JMU, that was 12 people or 13 people. And at the hearing, we could never get a majority vote to approve it because we could not, as an institution, ethically allow a piece of research to occur that could identify students at risk and not try to reach out to those at-risk students. And so we were caught in a quandary, and the quandary was, do we want to, you know, we really want to allow this research to take place because I think it's a very beneficial research, but we really want to know who those students might be that might be at risk so we could reach out to them and not depend on them to come to counseling to the health center. We wanted to be able to kind of reach out to them. And that was the institutional policy, was we were wanting to be very proactive on a lot of these ideas, and we were already doing a lot of stuff like that already. With this, we had just not done anything with, having to do with potential eating disorders. And so ultimately, after going back and forth and back and forth and back and forth with the researchers and all like that, and she couldn't really share that information with us because of the anonymity requirement in human subject research. All data, all information has to be reported in a non-identifiable, anonymous fashion. In an aggregate fashion, you can't report individual information, even if you know it. And so we were caught, kind of twixt in between. We couldn't allow the research for ethical reasons, and she couldn't give us what we wanted for purely, human subject research code reasons. And so we both kind of had to say, well, okay, maybe you should pick another institution that doesn't have as many ethical concerns as we do. And she did, and her research ended up being very, very influential and very fundamental in terms of some of the stuff we now do to identify eating disorders early, before they actually begin to have detrimental physical effects on folks. But we couldn't do it. We just couldn't do it. And so that was a conflict between the legal and the ethical at an institutional level, and we just couldn't do it. And so sometimes you run into, things like that where, it would be beneficial research. You just can't participate in it because ethical reasons you can't do that. And so there are plenty of instances where we don't, where even though something might be legal, it's just not ethical to do it, and so it's not done. Questions, thoughts, major concerns, minor concerns about any of that? All right, I'm going to turn off the recorder here because I want to use the same recording for the second section of the class. So we'll